Hello, and thank you for joining us today. I'd like to welcome everyone, including members of the media, to today's webinar, Antitrust Issues in the Food Industry During the Pandemic. This presentation will last 60 minutes. This webinar is available for 1 hour of CLE in California, Georgia, Illinois, New Jersey, New York, Pennsylvania, Texas, and Washington. And this is pending for 1 hour of CLE in Florida and Ohio. For all other states, credit will be applied for as requested. Please be advised that there will be 2 points during the program where we will pause for CLE verifications. During this time, a code will appear in the slide deck you see on your screen. Please make sure to write down this code if you would like CLE credit, as you will be asked for it at the conclusion of this presentation. A CLE and program evaluation will be available immediately following the conclusion of the webinar at 3 p.m. Eastern. Once the Zoom webinar concludes, an electronic survey will pop up in your internet browser where you will provide your bar number and any feedback you'd like to give on the webinar. If you have any questions, you can submit them via the chat box on the side of your screen. We will do our best to address them toward the end of the program. Now, I'd like to take a moment to introduce today's moderator. Carl Hittinger serves as Baker Hostetler's Antitrust and Competition National Practice Team Leader. He focuses his practice on complex commercial and class action litigation, with a particular emphasis on antitrust and unfair competition matters. Carl has more than 40 years of experience handling bet the company litigation and successfully trying lengthy jury and non-jury cases. He regularly counsels clients on all aspects of civil and criminal antitrust and unfair competition law, including clients at all levels in the food and retail industries. Carl, we'll turn it over to you.
Thank you, Kristen. Good morning and good afternoon to everyone. Thank you for joining us. We hope that the next hour will be informative to you and get you thinking about issues that you may not have thought of, or issues you have thought of, and maybe we'll provide some answers to those questions. We are living in a pandemic. The pandemic has great challenges to all of us as citizens, as consumers. But one thing that is common to every consumer, every citizen, is food. We all have to eat food. We all have to buy food. We all, at this point, are mostly eating food and buying food from our homes. Restaurants are just starting to open. And the pandemic has created, as you all know, everyone knows, judges, juries, everyone, and government enforcers, problems for people buying product at reasonable prices. There are shortages in all varieties of products, particularly in the food industry. Prices in many foods have increased tremendously. Pricing even for delivery services for food, for home delivery, have also increased tremendously. And these shortages, these price spikes, these change of quality of food, these choice restrictions all create suspicions and optics that we as antitrust lawyers have to deal with all the time in our practice. But it's particularly more challenging during a pandemic, because American consumers are asking a basic question. Why are prices so high in certain foods? Why is choice limited? Why is production, in many cases, down? Why aren't producers, why aren't distributors, why aren't retailers making more product, selling more product, and why aren't they competing more in the marketplace? So when you see a product spike up in price, and then the other producers follow that spike and everyone's charging higher prices, that creates suspicion. And those optics and that suspicion is what causes antitrust investigations to be brought and private lawsuits to be brought as well. So we see so far problematic issues arising during this pandemic. I'm sure you've seen them too in your businesses. And so today we're going to address some of those things. And we're fortunate today to have two former DOJ antitrust enforcers, Ann O'Brien and Jeff Martino, who both each spent 20 years with the Department of Justice Antitrust Division in various positions. Jeff, most recently when he left, was the head of the Antitrust Division office in New York. Ann was in the DC office and had various high-level positions at the Department of Justice Antitrust Division, handling compliance issues, policy issues, enforcement issues. And so between the two of them, you have some tremendous experience from a government perspective and a recent government perspective, because they both all left in the past year, about these issues and how they could be handled going forward. So we're going to talk about the antitrust risk both civilly and criminally, and we're going to go over all those topics in the next hour. And at the end, we're going to pose a hypothetical, which we hope will pull things together for you. And then we're going to have a question and answer period if we have time remaining. If we run out of time, you can certainly submit your questions and we will follow up and we'll answer those questions for you. So next slide. These are the topics we're going to cover today. We're going to start with context of the pandemic. We're going to remind everybody about basic antitrust laws and how they operate, and that will pull things together as we walk through the real world examples of what's happening in the food industry right now in terms of antitrust enforcement and lawsuits. We're going to talk about new developments in antitrust in the employment market, no poach, things like that. And Ann in particular is going to talk about price gouging, because as you know, there are 40 states that have price gouging laws of various types that deal with the kind of thing that we're experiencing now, but it's not uniform. It's really state by state. We're also going to talk about online platforms and sellers that sell food products of various types and distribute them. And then we're going to talk about collaboration and how collaboration between even competitors can be done in a legal way based upon certain guidelines that the government has issued if they're carefully monitored and structured. And then we're going to talk about the retail sector as well. So we're going to start with, talking about the production sector, the distribution sector, and then down to the retail sector where food is being sold, supermarkets, other kinds of stores, and those retail sectors raise serious issues about market allocation, restrictive covenants, exclusive agreements, all raise antitrust issues, which are even more problematic now because of these shortages and these high prices. So then we're going to drift into a hypothetical using a product that I thought, well, what product is hardest to get during this pandemic? My vote's for tomato soup. Can't get tomato soup any way you try, either at stores, online, it just isn't available. But we're going to use that as the example to make some of the points that we're going to talk away. And then we're going to give you some key takeaways based on our discussion. So with that, next slide, please. Let me start with some basic things. So we're in a pandemic. What's the pandemic causing? It's causing demand fluctuation. It's causing tremendous, staffing and workforce and transportation problems. It's in some cases causing plant shutdowns and other events that are affecting supply of food products, both from production to the distribution to the retail level. This is all resulting in shortages and price spikes, all driven by these shortages. And the one thing we're going to talk about today is just because we're in a pandemic, as bad as that is, as difficult as it is for all of us, that doesn't mean that the antitrust laws have changed. They haven't morphed into something different, and it doesn't justify necessarily, and we'll talk about the exceptions, conducting yourself in a way that if we weren't in a pandemic, your conduct would be illegal. It's really still illegal in a pandemic. The defenses aren't much different, but we'll talk about all those things as we go through it today. So these shortages, these price spikes aren't necessarily the result of anti-competitive behavior at different levels. But again, the perception, the suspicion, the optics of high prices, less demand, raises antitrust concerns. It always does, and particularly now. Next slide, please. So just again, to put things in context, we're dealing with certain antitrust statutes here, mostly federal, but there's also the states have their own antitrust statutes. Sherman Act, of course, is first and foremost dealing with agreements among competitors, dealing with unilateral conduct by monopolists. And there's certain things that are still per se illegal, even during a pandemic: price fixing, bid rigging, restrictions on output and supply, customer and territorial allegations. And now adding to the equation, which Jeff will talk about, are no poach agreements that the Department of Justice in particular is concerned about, both civil and criminally. So with a Sherman Act violation, you don't need formal agreements. You have an agreement to compete and boycott, an agreement to allocate markets, an agreement to price fix. All can be alleged and shown through conduct and parallel kind of conduct that can cause those things to hurt competition. Then we're going to talk a little bit about predatory conduct that is particularly important in this industry where you have sometimes very concentrated segments of the industry where there's very few producers or very few distributors, or even on a retail level, there's very few sellers. So you all know, being consumers, that when you go shopping, there's only so many supermarkets, so many places to buy food. And usually in those shopping centers, there's one supermarket, there's not two. We're going to talk about how that can raise antitrust issues. Next slide. The other thing we're going to talk about is vertical conspiracies, not just horizontal conspiracies. So in the food chain, going from production to distribution to retail, all along that, you can have vertical conspiracies, which aren't necessarily per se illegal, but they can raise some serious antitrust concerns. So Robinson-Patman Act, prohibiting price discrimination, comes into play with all the things we're talking about. If there's less product, if there's more demand, people may want to select who they sell to and what price they sell to, have favored customers, disfavored customers. That can lead to Robinson-Patman Act issues. The Robinson-Patman Act deals with price discrimination among similarly situated buyers. There are certain defenses that are available, meeting competition, changing conditions, cost justification. Those are defenses that can be raised in certain circumstances. Has to be the same product, has to be a product, not a service. Example is, a distributor giving discounts to chain supermarkets, but not independent markets. If they're similarly situated, that can lead to the issues. If there's a volume discount, that can possibly be a defense. But you have to keep an eye on that issue, because the Robinson-Patman Act violations, like Sherman Act violations, can result in treble damages, which are automatic, can result in having to pay attorney's fees. You don't get your attorney's fees back if you win, but if the plaintiff wins, the plaintiff gets their attorney's fees. It can result in very onerous consent decrees that can last, for years. It can also result in injunctive relief. And if you're doing government working, it can result in debarment. These cases, the antitrust cases, are typically not covered by insurance. It's right out of the company coffers, and therefore it's serious business and should be taken as so. The other thing I just want to mention, this is an equation. We have Jeff and Ann from the Department of Justice, but also the Federal Trade Commission is very actively involved, as are the state attorney generals, in the kinds of issues we're going to be talking about today. And do not forget that the Federal Trade Commission has a Section 5, which covers unfair and deceptive acts or practices. It's that broadly worded. It's actually, many argue, broader than the Sherman Act in terms of the conduct it can capture. And under Section 5, only the FTC can bring the case and seek injunctive relief, but they can also get fines, and those cases have been increasing with the fines that have been awarded. And then you have state antitrust laws, both the antitrust laws and related kind of laws, and some of the related laws allow for disgorgement of profits. If you make profits based on your illegal conduct, you have to disgorge those profits to the plaintiff, even if the plaintiff can't show damages. And that can be, a lot of money if you are profited by the conduct. So let me turn it over to Jeff now to talk about some real world examples of things that are going on right now in the food industry. Jeff?
Great. Thanks, Carl. It's a pleasure to be here to talk through these issues with you and Ann. As Carl has mentioned, there are a few food matters that we want to highlight to demonstrate the type of conduct and the level of scrutiny that the food industry has attracted over time and will certainly continue to attract as we proceed through the pandemic and then hopefully come out of it in the following months. As a former prosecutor, there may be a few general reasons why food cases draw such intense scrutiny, particularly from the Department of Justice, but also from consumers and the other antitrust agencies. And first, as Carl has mentioned, there's just fewer competitors in some of these more concentrated markets, allowing for more significant opportunities for competitors to have contacts with each other through trade associations, industry conferences. They get to know each other more and feel more at ease talking about what they're going to be doing. Second, many food companies often face challenges characteristic to that particular industry, with perishable products, seasonal availability, and weather-determined supply that are just a few of the reasons for the variability. And the industry inherently can be unpredictable, with the supply and demand dynamic changing constantly. And during a global pandemic, it could certainly increase those those dynamics and those fluctuations, causing the market, the competitors within the industry, to want to stabilize that. And third, antitrust cases, they in the food industry, these are items that are on your dinner table, in your child's lunches, and it's easy to explain that for a prosecutor to a jury. Many criminal antitrust cases can be so difficult to convince a jury to even care, right? But here, the details are not that complex when you're talking about something that everybody can relate to. It's not a market manipulation case. There's not difficult pricing structures, or if there is, those can be, excuse my phrase, but boiled down pretty easily for the jury, because they're not having to grapple with those difficult concepts, and they're talking, and the government's going to be explaining, what they see every day. And so that's just not the case for food. It's easy to explain. So some of the cases that we've listed here, the food brokers bid rigging, this was back in June 2000. And I note this one just because to demonstrate that these types of cases have always been a high priority of the Antitrust Division. In fact, this was one of the first cases that I had worked on as an intern, and it certainly attracted my attention to become an antitrust lawyer and a prosecutor. I thought, wow, if all cases are like this, this is going to be a lot of fun. And here, what was involved was school lunches provided to the New York City's public school system. The New York City Board of Education operates the public school system, and which is one of the largest in the United States. There were two conspiracies that involved almost all of the Board of Education suppliers of frozen foods, such as fish sticks, meat, French fries, and all of its supplies for fresh produce as well. The conspirators discussed and agreed on prices to bid, refrained from bidding. They submitted intentionally high or complimentary bids on contracts, and then they paid potential bidders not to bid, including a single payment of up to $100,000 in cash to one produce supplier. They shared net profits with each other by giving each other free merchandise or other money cash payments. And they certified falsely that their bids had been arrived at independently. So in just this one case, not only did you have antitrust violations, but you also had tax violations, fraud violations, and false statements. All told, 22 individuals and 13 food companies were charged with rigging the bids on these contracts. And the contracts totaled, I think, over $200 million that were at issue. Another reason I highlighted this particular case, because the food brokers case is just the type of matter that would now be the focus of the newly established procurement collusion strike force. In November of 2019, this is before the pandemic, but certainly it has existed throughout, DOJ announced it formed a government procurement collusion strike force that comprises of prosecutors not only from the Antitrust Division, but 13 U.S. attorneys' offices from around the country: New York, D.C., Chicago, Ohio, Los Angeles, and other key markets. And the strike force partners with FBI and other inspectors generals from the Department of Defense, Postal Service, GSA, and many others. And the mission of the strike force is to deter, detect, and prosecute antitrust crimes, as well as related schemes, which this food brokers would have fell right into the purview of the strike force. Just in this past year, it was projected that contract spending by the US government and other local governments would be close to $600 billion. DOJ has said that more than 50 federal, state, and local agencies have sought the assistance of the strike force since its inception. They've trained 2,000 investigators. Some of those include data scientists who evaluate bids and pricing patterns, as well as procurement officials, all to assist them in trying to uncover bid rigging and fraud in the procurement process. Prior to the strike force, the division already had, I believe, at least 30 investigations open into public procurement fraud and collusion. But since the strike force has been operating, they've opened up another 20 or so cases. So that's 50 cases that the strike force is looking at across the country. So that's something that we thought was important to note, especially for the food industry, where they are dealing with public procurement. The next case we want to talk about is the tuna price fixing case. And here, this was a conspiracy to fix prices among competitors that supply tuna. And what's notable about this case is that there's only 3 or 4 major tuna suppliers, at least that were supplying the United States market, and 2 of them decided to try and combine. And it's during that merger process that was being reviewed by the antitrust authorities that documents were uncovered that disclosed that they had been fixing prices. This ended up resulting in $125 million in corporate criminal fines and a 40-month jail sentence for one tuna company CEO. In general, individuals can be sentenced up to 10 years in prison. And so, but not only was there the criminal case, but there are certainly private civil lawsuits filed after. Currently, there is one in California comprising of 4 different classes of purchasers that are also seeking punitive damages. Again, what was notable here was the conduct was discovered during a merger. This has been the increasing trend of how some DOJ investigations are being uncovered. FTC staff, DOJ staff on the civil side who review the mergers are trained to certainly spot issues that would raise criminal concerns and make those referrals over very quickly. And lessons learned here is that it's important to have antitrust counsel doing due diligence during those merger review and prior to turning over the documents to the government, so you can get ahead of the issue and be able to deal with it appropriately. Here, there was a leniency applicant, so one of the companies did come in and report, but this was already after the fact, right? And so they weren't able to get all the protections that may have been available to them if they would have disclosed this conduct prior to the government becoming aware. The peanut price fixing case, this is a civil case at this point. The class is comprised of peanut farmers and harvesters that sell raw peanuts to the defendants, who then process, shell, and sell the final product to food companies or other manufacturers. According to the class plaintiff's amended complaint, beginning as early as 2014, 2 of the major players controlled about 80 to 90% of the peanut shelling industry. And they conspired to suppress and keep stagnant prices paid to farmers for raw and harvested peanuts. The class alleged that the defendants used their supermajority share to control the market through trade associations and exchange of information through trade associations. Turning to the broiler chicken price fixing bid rigging case, there DOJ recently came down with an indictment on June 3rd of this year in the District of Colorado, where they charge executives from a major chicken supplier. This case was filed in that particular district because that's where the company of the executives was located. Now, the chicken industry is also dominated by a handful of companies that have over half of the market share. One of the companies did here to apply for leniency and released a statement saying that the company, and this is a quote, has been fully cooperating with the DOJ as part of its application for leniency under the corporate leniency program. The company noted that it had received a grand jury subpoena in 2019 and immediately provided information to the Department of Justice, as it self-reported. I'm not familiar with all the details of the case, but as far as the lead up of what's not public. But what's interesting to note here again is this came out of a civil case, a private class action, and then DOJ came in after the fact. So any leniency application again would have been after the DOJ was already aware of the conduct, and so the company would not, I believe, not be able to take full advantage of what's referred to as type A leniency, meaning that all current key executives who participate and are willing to cooperate would be able to get a non-prosecution agreement. So while the antitrust lawsuit and government investigation in the poultry industry preceded the pandemic, the industry should expect continued antitrust scrutiny. There may be more indictments coming down, particularly given that the supply and demand pricing concerns And we expect, maybe not this in this industry, but what we have seen in other industries, in dairy, pork, and beef recently, is that the Justice Department has been actively following in any class actions as well. So we can now go to the next slide and turn to antitrust in the employment market. So back in October 2016, DOJ and the FTC jointly issued guidance to human resource professionals, and they addressed employee no-poach agreements and agreements between two or more employers that would restrict employee recruiting or hiring. At that time, the Department of Justice stated that going forward from that point, it intended to criminally investigate naked no-poach agreements or wage-fixing agreements that are unrelated or unnecessary to a larger legitimate collaboration between employers. Agreements that do not constitute criminal violations may still have led to civil liability under the statutes enforced by the agency. Before the guidance was released, the Department of Justice only brought in civil enforcement actions, and particularly in relation to technology companies for no-poach agreements, where each company agreed not to call each other's employees in order so that they would not be hired away. It's also important to note that no-poach agreements, wage-fixing agreements fall certainly within the purview of various state consumer protection statutes, such as the California Car Right Act and Washington's Consumer Protection Act. A couple examples here that we note is one in particular is for the food industry, is a no-poach matter, where in 2017, 32 of the biggest fast food chains, including some that we all see on the corners almost of every other block, prohibited their franchisees from hiring workers away from one another. There were private class action lawsuits, as well as several significant attorney general investigations that followed. And now many of these fast food companies no longer have such non-compete or non-hiring clauses in their contracts for their franchisees. The other one we wanted to note is, again, back into the chicken industry and wage fixing allegations. This case is moving forward against processors. The workers have claimed that top executives at some of the major chicken companies exchanged non-public worker compensation information at seminars and conferences around the country that were organized by trade groups, as well as off the books, that's in quotes, meetings at a particular resort in Florida. The employees alleged some of the biggest companies would take turns paying for the expenses at these meetings, and that was one of the primary purpose of these meetings. Allegedly, this was bolstered by similar informal information sharing among the managers of competing plants, as well as services provided by AgriStats and WMS. So the workers have said those companies evaluated compensation and benefit, or had compensation and benefit surveys that may have assisted the conversations between the competitors. Some of these claims have been tossed out recently, but the case is still expected to go forward on certain claims. So we've highlighted some of the significant cases in the food industry, and as far as how it relates to the no-poach, as well as other horizontal agreements that may certainly grab the attention of DOJ. And at this point, I'll turn it over to Ann.
Thanks, Jeff. So move on to the next slide, and I'll talk about price gouging. Price gouging is obviously a hot topic during this pandemic, really, just to give some context, as it has been after past crises. So when I was at DOJ for 20 years, I'd often get called in after things like Hurricane Katrina, for instance, or other large storms that would trigger state price gouging laws. Now, those were different from what we're seeing today, because those were things that happen in small regions. So the Southeast might be experiencing the ripple effects of a hurricane, and things like gasoline and water and materials to rebuild homes and businesses would be deemed essential products in states, triggering these laws, and you'd see common complaints of price gouging. But typically they were kind of short-lived concerns, and they were regional. Now with this pandemic, like everything around the world is upside down. And this is the longest single state of emergency. It's the national state of emergency. Every state has a state of emergency. The longest one, it's national, it's international. So it's not limited like we saw before. And in these price gouging laws, I mean, I have a slide up here to, just a simple definition for what is price gouging. It's when a seller increases prices on essential products to exorbitant amounts to capitalize in an emergency. It's basically a concern about profiteering. And really, at its core, I mean, that's just a simple definition, but at its core, the idea is companies shouldn't be profiteering and taking advantage of people in a bad situation. Now, but what does profiteering mean? And how do you not be a profiteer? This is really complicated currently when we are looking at this web of statutes that's been triggered for a long time. And we work with companies and they often say, don't I have a right to charge whatever price I want for my product? Absolutely you do in normal times. We are not in normal times. We are in a national state of emergency that has triggered 40 state laws, and the District of Columbia have these laws on the books. And never before have we ever seen a federal price gouging law triggered like we have during this pandemic. There is no statutory federal price gouging law. But what we have is that on March 23rd, there was a presidential executive order that invoked the Defense Production Act and prohibited hoarding and selling in excess of prevailing market prices. And that's not defined, and we don't really know what that means. But the HHS gave a list of the products that would be covered. And it's primarily PPE and health-related products, ventilators. Some disinfectants aren't there that are on the list that find their way into retail. But the good news for most of you on this webinar is that food products and other retail products like toilet paper are not really included on that list. They are not included on that list, so you won't be subject to the federal statute. And other good news is there's a lot of focus on this from DOJ, and there's a hoarding and price gouging task force. But the kind of cases, and we've been following closely, we're seeing are really resellers of PPE, masks and gloves that are selling them out of their shoe shop or their auto body repair shop. They're not large retailers that are really seeing criminal prosecution, because it does carry criminal prosecution possibility and also fines. So you're unlikely, and most of you on this call are unlikely to see the federal statute kicking in for products that you sell, other than maybe some disinfectant products. But the state laws are where we're seeing a lot of activity on price gouging. So there's 40 state laws. They're all triggered right now because they're typically triggered by a state of emergency. And they go away when the states of emergency cease to exist, but we've all seen those extended in all of our states and regions and at the national level. The tricky thing about these statutes is that they vary quite a bit. Some are really specific, like New Jersey and California, that have a particular price cap. So this is where typically you can set your own prices. These actually have a number that you cannot increase prices by. So pre-pandemic prices, post-pandemic prices cannot go up more than 10%, or you are potentially subject to civil or criminal prosecution under these state laws. Now, the good news is that a lot of them do contain an exception or an exemption for passing on costs. So we do see that a lot. The way these develop is really interesting. I mean, often it can be a single sale of a loaf of bread, a single gallon of milk. I see this every day with clients who are calling and they've received letters from state AGs or local authorities because a customer complains. And that customer has no idea why the price is what it is. It's just more than what it was when they bought it previously. A lot of times it's not even the same product that they're buying, and they perceive prices as being higher. Sometimes there are reasons because of increased sales costs or things like that. But for whatever reason it is, it can cost time and money to address these, because essentially the retailer will be sent a letter. The retailer will then have to say what they purchased it for. The distributor may then receive a letter. Essentially, state AGs and local authorities will continue to go up the chain and figure out if there is an inordinate price increase that is a gouge, and where that is. So onto the next slide, Kristen. So before we switch to this, just another thing I wanted to touch on was a really interesting thing that I've just started to come up, which is kind of advising on pricing strategy during the pandemic and after. Sometimes if an algorithm is set to have an automatic price increase, it is triggering price increases automatically without any human interaction. And if that algorithm is set to things like what other competitors are selling for or demand spikes, those can go up and potentially be violative of some of these price gouging statutes, even if no human is involved. So, it is time to think about pausing automatic algorithms, getting more human involvement and override on those, or certainly consulting with counsel on that. Moving to price gouging and price fixing. So, Jeff talked about some examples of price fixing. Price fixing is a statute that's not triggered by any pandemic. Price fixing laws, the Sherman Act and the state equivalents, prohibit this conduct all the time, even when there's not an emergency. And they are an agreement among two or more horizontal competitors, where price gouging are unilateral pricing decisions made by a seller that are deemed to be profiteering. Both can carry civil and criminal penalties. The price fixing one's much higher, as Jeff mentioned. Next slide, please. So a few examples, there are a number of examples, but we're seeing some action both in private lawsuits and by some state AGs. There's these complaint kind of investigations that I described on price gouging, but there's also lawsuits brought. And just to draw one example, there are a few egg prices. People had trouble getting eggs in some instances and saw higher prices. And there were lawsuits brought by the Texas AG, which was recently dismissed pretty quickly, and a lawsuit by the New York AG relating to increased egg prices. You can see the chart there showing why egg prices went up. Much of that may be because of supply or transportation issues. But again, consumers and enforcers don't necessarily know that, so it has to be explained. And there were private class action. There's a private class action in California alleging price gouging on eggs. Now, really interestingly, when this Texas AG's lawsuit was dismissed by the judge, she didn't really mince any words. In her one-page decision, she called the state's case unconstitutional and having no basis in fact, and saying the case is really about the state's unconstitutional rejection and attempted manipulation of the free market and existing contracts between sophisticated businesses. So part of me wants to clap after reading that, because I do see that as an issue, and there are arguments there. And I think some of this litigation there really isn't a lot of precedent in the price gouging area, and some of this litigation may lead to some positive precedent. So moving on to the next slide. Quickly, I just want to touch on some interesting issues that have come up with online platforms. There was an April lawsuit that was really interesting involving online third-party food delivery platforms sued by a class of customers for a variety of antitrust violations, kind of a kitchen sink of violations, including monopolization, price fixing, not necessarily price gouging. And they weren't related to pandemic prices, but it was filed after the pandemic. And it struck me that, this was really relevant to people when so many people were sitting at home ordering from these type of platforms. And they made allegations about increased costs due to some contract terms for restaurants. But the people that brought the suit weren't the restaurants. They were the users of Grubhub and DoorDash and the like. And then there were later some restaurant cases, and those haven't been resolved. So we'll see them work through this, the legal system. Also in April 2020, there were some major online retailers charged in multiple lawsuits alleging price increases, price gouging due to the pandemic. And these were really interesting because these online distributors were sued even though they didn't set the prices. And really there is a lot of pressure here. I mean, there's intense scrutiny on big tech generally, some call it techlash in the antitrust world. And you see that 33 state attorney generals really sent a letter appealing to online retailers, asking them to crack down and them to police price gouging. So that was also interesting. Moving on to the next slide, I think we have a announcement.
Please record the code Antitrust 1 for the post-program evaluation. This is the first of 2 codes. Please make sure to write this code down if you are requesting CLE credit, as you will be asked for it at the conclusion of this program. Antitrust 1. Back to you, Anne.
So I'll just cover one more topic, which is really something Carl mentioned at the beginning, that these can be scary times on a number of levels. And, some of the things we've talked about, really focus on illegal competitor collaborations. But competitor collaborations are actually really important, and they can be really positive in a time like we're facing now with the pandemic, where competitors, in the same industry are facing the same concerns and challenges and constraints, and people need products and they can work together to get people those products. So there is a real recognition recently of that by the DOJ and the FTC really early in the pandemic, March 24th. The FTC and DOJ did a joint statement highlighting the important role of those collaborations, and, in an effort to promote collaboration, laid out some items that are more likely to raise concern and some that aren't. And they did a pretty cool thing. And I'm, kind of proud as my old section at the DOJ promised to review expedited business reviews in 7 days. So that's lightning fast for a DOJ. And there's a lot of people, my former colleagues, working very hard to review these, which means that if you think that there's a collaboration that would benefit you with a competitor, but you have some antitrust concerns, there's a vehicle to go to them and get a quick, basically advisory opinion, if you will, although they'll never call it that, but a forward-looking blessing of what you're doing, saying there's no present intention to challenge that. And in the food industry, the National Pork Producers Council did exactly that. When they were faced not with a shortage of supply, but an oversupply, they went and got the DOJ's blessing in a business review letter about a proposed coordination of hog slaughtering, so that was not viewed as an illegal agreement. They wanted confirmation it wouldn't be viewed as an illegal agreement among competitors to control supply. So I think this is a good tool potentially out there to use during the pandemic to kind of highlight and get agency views on proposed coordinated agreements. So I think with that, I will send it back to Carl.
We wanted to spend a few minutes before we go to our hypothetical talking about the final sector in the food chain, which is the retail sector. And there we're talking about the companies and stores that actually sell food to consumers. Now, how does the pandemic impact on this? It impacts on this because what before the pandemic might have been looked at as a competitive environment in most cases, now with higher prices and lower supply, again, the suspicion, these optics come into play when you're dealing with things on a retail level. So the issues I want to just briefly talk about was, take shopping centers. Let's start with that, where you have a shopping center and you have a supermarket in the shopping center. And the supermarket reaches an agreement with the shopping center owner that they will not put another food store in the shopping center. Okay, fine, protects that food store, protects the center. The food store then is the anchor store in the center. But if that shopping center food store raises prices, decreased demand because of the pandemic, then the suspicion is, well, maybe this is taking advantage of their basically monopoly position in that local market in order to hurt consumers. And that could create lawsuits, that could create investigations, because when you're dealing with these retail sectors, it's not a nationwide market, it's not a state market, it's a local market. And the local market may be limited to where people would typically shop within a certain area and not drive to, and that could be very isolated. So you may only have one or two very highly concentrated competitors in that particular market. So restrictive covenants exclusivity arrangements, all these things take greater meaning when you're dealing with a pandemic and limited distribution. The other thing that comes into play, because we have these small markets and you can have, major market power, and that's usually over 50%, is a person who has that kind of power wants to make sure that they maintain it. And they don't want other competitors coming into their market and selling food. So they don't want other supermarkets coming in or other retail outfits coming in. And they will do things that would typically be called predatory conduct under Section 2 of the Sherman Act in order to stop that. And so they may engage in, zoning activity to stop their competitor from getting in. They may try to restrict supply or use exclusive agreements to make sure that that competitor coming in, once they get in, can't get the product they need at the prices they need, and therefore, using their monopoly power, they're able to basically control that market. And sometimes in a per se way, if they agree with other competitors in that market to do that together. It can also be vertical conspiracies, which we talked about before, raise their own set of issues, but can be illegal. So let's not forget that retail sector, because that can be a very complicated area. Usually private litigation ensues from that. You could have consumers bringing lawsuits, but typically it's a competitor versus competitor situation. Sometimes municipal authorities get pulled into those cases as conspirators based upon the kind of zoning issues that sometimes pop up. So let's go into a hypothetical that may be of benefit to you to pull things together that we've talked about so far. Like I said, I picked a product that's I think is still hard to get, which is tomato soup for some reason. Not saying there's anything going on there, but just raising that as a good example. So people are at home. Comfort foods are more important to us than ever. Tomato soup and soups are not things you typically are getting on takeout. They're just either not available, or taking out soup is always a complication. And it's a product that everybody uses across the board. So let's take a situation where it's a fairly concentrated industry. Let's just assume for concentration, there's 3 basic soup producers that make tomato soup. And because of the pandemic and because of the restriction in available product that's caused by principally, labor shortages, both at the production plants for the tomato soup, the plants that make cans, the plants that make tomatoes, all those things go downstream. So it's harder to get the product. The product you need to make it is more expensive. And as a result, the prices have a cost justification, like Ian talked about, but how much of a cost justification do they have? So let's assume that one of the producers decides, because of all this, I'm going to raise my price of tomato soup, and I'm going to raise it by 4 times what it normally is in the marketplace. And they do that, okay? After they do that, they have an opportunity to talk to 2 of their other competitors. And they do this at a trade association meeting, which now, of course, is all virtual. But as you know, there are chat rooms. People can break off and go to their own little rooms. And so suppose they have a discussion in that chat room where there's 3 producers, one being the price leader and the other 2. And one of the producers says, hey, wouldn't it be better if we all, for the sake of the consumer and ourselves, then release the product in waves. Didn't just dump the product in the market as it's produced, but try to coordinate this a little bit. So, one producer would produce a wave of product, then the next producer would produce a wave of product maybe a couple of weeks later. And that way the market gets what they need. We're not dumping it on the market. People get what they require, but we do that in a kind of a systematic way. And on this particular call, the one producer says, that's a great idea. And another producer on the call says nothing. They just listen, don't comment. After the call's over, that's exactly what they do. They start selling the product in waves, okay? They also do, which they did not talk about on the call, is the other 2 producers who were not, increasing the price of tomato soup decide to follow the price leader and increase their the price of tomato soup to meet that price leader's price, okay? Now stop it there, and I'll turn to Ann and Jeff to talk about, first with Ann, is there price gouging there, and who would be liable for that?
Well, like any good lawyer, I'll say it depends. The facts, as you address them, Carl, is a 4 times increase in the cost. If I have a client call me and say, we've quadrupled our price, I'm going to be a little concerned in the pandemic because some of these states, as I described, have a 10% price cap. If it's the pre-pandemic price is capped at 10% from the post-pandemic price. Now, because of those exceptions I mentioned, that most state laws contain the ability to pass on increased costs. So if a client called me and talked about that, and let's say they got a letter from a state AG, I'd say, well, what have your costs increased? And by cost, that can be pretty broad. Every transportation costs have your costs of buying the products to manufacture it. The tomatoes, has that increased? Are you paying more for staffing? Are you paying more for PPE? Are you paying, there's a lot of things that goes into increased costs. And those are certainly increases to a company. And I think the price gouging laws do allow companies to pass them on. What is critical is documenting those. So just saying you're increasing 4 times because we're in a pandemic, that's problematic. So pandemic pricing increases, as I've seen some things labeled, not a great thing to label it, but if it's increased cost adjustments, and you're passing on a typical margin, your typical margin on top of increased costs, it really might be okay on the price gouging front there, Carl.
Okay. Let me throw it to Jeff. We have, a phone call with 3 producers in a highly concentrated industry. They discussed what we talked about, which is staggering supply. They don't talk about price, though prices do go up after the meeting, as well as the staggering of supply. Jeff, any horizontal conspiracy issues there, civil or criminal?
Well, first, your academic background, Carl, is definitely on display here. Many people may not know that, but Carl is a law school professor as well as a very good practitioner. And Ann's answer was an A from my perspective. But as far as the horizontal aspect, certainly you've got competitors talking virtually in a room, right? And so there, you're going to have issues because they're talking about what's going to happen going forward. This is in the context of a trade association where we always advise clients that to stick to the agenda, don't talk about prices, make your own pricing or supply and demand decisions on your own. And if you hear those conversations, make a noisy exit, hang up, say you're not participating, and move on.
Let me throw in another element, further fact. So this all happens, and then these producers, to make sure that this works, each tell their own distributors that first they have to maintain the price that they've upped it to 4 times, but the distributor can include, a 10% upcharge, which is what they typically charge for the distribution duties they perform. But they also tell the distributors that we don't want you selling this to any, online retailer, any service online, because we're concerned that if it's sold online, considering the food that we're talking about, tomato soup, that it might be sold at a discounted price. It might be sold in a defective way, dented cans, expired cans. We're concerned about that. And of course, it's a fungible product, so you're concerned about storage and things like that. So they say to distributors, you can only sell it to supermarkets directly. You can't sell it online, but you got to maintain the price. First, Ann, any price gouging liability to the distributors for agreeing to that?
Well, on the price gouging front, we actually saw something like this in the PPE side of things related to mask sales and sometimes gloves. But some of you might have seen 3M actually filed some lawsuits where unauthorized resellers were selling their products, their mask products, their 3M branded products at really high prices, and were subject to, it was subjecting them to reputational harm, which is a real harm, a real risk of harm, because those, that was being criticized publicly in the media and by consumers. And so they said, hey, you can't sell our products, our 3M branded masks, for more than a certain amount. So say you're 10%, which keeps you in, there really unfortunately isn't a safe harbor for price gouging, but it would keep you within that. And it really should benefit consumers, right? If the prices that are limited. So is that legal? Probably. I mean, it is. There's these RPM, retail price maintenance line of cases that can be problematic. But if you're looking to cap, the resale of your product so as not to harm consumers, I think that's unlikely to raise scrutiny. And these 3M cases were really to defend their brand more in the trademark realm, not antitrust cases, but to defend their brand as 3M products were being sold all over the place by unauthorized resellers. So there's that issue. I think the more problematic part with this fact scenario is the potential, market allocation agreement. So if competitors get together and say, don't sell to online retailers, only brick and mortar retailers, then I think you have a horizontal concern that could potentially be, a criminal violation, a criminal conspiracy to not sell to certain customers. That falls in the traditional area of market allocation that could lead to very serious criminal penalties for companies and jail time for executives.
Mm-hmm. Chuck, what do you think? This is, again, the producers aren't agreeing among themselves to not sell it online. They're just telling their distributors that that's what they must do. So it's kind of a vertical situation, but they are boycotting those online resources through the vertical conspiracy. So any criminal implications there, or is it more a civil issue?
Yeah, I think again, you have to see how the facts play out with what the communications are. But you can have vertical agreements that are orchestrated by a horizontal agreement. If there is that horizontal where you have the competitors themselves deciding on how they're going to deal with their distributors, affecting the supply, which ultimately affects prices, then there's a theory there that could lead to a criminal violation.
Carl, I'd also just add that these are real world scenarios in trade association meetings. Jeff and I are getting calls. Other partners are getting calls where these type of invitations to collude might happen, where people say, "This is really tough times. Let's work together." And if it involves future price or future supply, there's a real issue there. And so even if you say nothing and you stay on the Zoom, you still could be within the umbrella of suspicion if DOJ comes looking and your calendar shows you were on that Zoom call. Heck, maybe it was even recorded. Even if you did not say anything, no affirmative agreement is really required. If you leave and go back to your desk and then do what everyone agreed to do and raise prices or allocate or do whatever, that could be a real problem. And we do get those calls, and our advice will always be noisy withdraw, mention antitrust compliance training that Baker Hostetler did for you, and leave, because this is a real situation that people can run into.
Okay. And final question I ask both of you, again, we're dealing with a pandemic situation where the producers, suppose they say to the Department of Justice, who then investigates this, look, we were just doing this to help consumers. There was limited demand and limited supply. There's great demand. We had increased costs, particularly with the online sales. We wanted to make sure that consumers weren't getting product that was defective or unsafe in any way. Is that going to cut any slack with the enforcers in the long run because we're in a pandemic, or is the antitrust laws the antitrust laws?
The easy answer is the antitrust laws are the antitrust laws, and talked about competitor collaborations and perhaps an opportunity there to highlight what you're trying to do to address the pandemic. There may be certain collaborations, but when you're, as Ann had already stated, when you're talking about what you're going to be doing, that's certainly the antitrust laws haven't gone away during the pandemic in those situations.
Okay. Kristen, I think we're at the top of the hour here, and we have some limited questions. I'd like to say that we'll answer the questions when we after we're offline. But Ann, why don't you just quickly go through the takeaways that we can tell our listeners today?
Sure. And I think these are really top line takeaways. Always set prices independently. And Jeff and I talked about some of the perils that can happen if you're talking to competitors about future pricing. Be wary of collaboration about future prices, supply or allocation, or customers who you're going to sell to, how much you're going to sell, reducing supplies. just be aware of the price gouging laws, and when they're triggered, as they are now, document price increases. If they're due to cost or supply issues, document those. It's very critical to responding to those concerns. If you're considering collaborating with competitors, seek legal advice and consider one of these expedited reviews, which we can help you with. And obviously, we always give a plug for antitrust compliance. You know, antitrust is its own animal, and a compliance program that is effective and that really addresses antitrust risk, not just general risk, is really important to have in place.
Well, thank you all very much for listening today. We hope we answered questions. We raised questions for you to think about. We're certainly available to talk about things further. Kristen, I think you want to finish it up with some housekeeping issues.
Yes, this is the second of 2 CLE codes. Please record the code Antitrust 2 for the post-program evaluation. Please make sure to write this code down if you are requesting CLE credit, as you will be asked for it at the conclusion of this program.
Thank you very much, and take care, everyone. Bye-bye.